Good afternoon, everyone. Good afternoon. Welcome to this edition of The Law and You. I'm your host, Attorney at Law Shellon Washington, licensed in the state of New York, in my home country, Guyana, and in Island of Trinidad and Tobago. Guys, it's a pleasure to be here this afternoon. We're going to be speaking specifically about an issue that may be affecting small business owners, particularly those who are engaged in the trade of home renovation, renovating property for people. That's what we're going to be speaking about. It relates to your money. How do you get paid? How do you ensure that you get paid? I have today with me a co-host, no stranger to some of you guys. We've been on here multiple times together, and appearing with me here today to speak about this in more detail. And in particular, he is licensed in New Jersey, which is a state that he's going to talk about as it relates to the issue we're discussing today. Welcome today with me, my co-host, Claremont M. Mali. Well, the M is for Mali Chung.
Thank you, Shellon. Thank you for having me, and it's my pleasure to co-host today's show.
Okay, so we're going to be getting right into the show. Thank you for joining me, Claremont. We're going to be getting right into it. As I said before, guys, we're going to be speaking about what's something that's called a mechanic lien. And this is going to be something of great interest to those of you who are in the trade of home renovation, property renovation, for your clients, for whoever you're performing the job for or the work for. So we're going to explain to you how you go about getting paid. How do you ensure that you don't just work for somebody, but the person also compensates you for your hard labor. And we're also going to touch on issues where a lien is wrongfully placed on a property, how to avoid that mistake of having to place a mechanic lien on the wrong property, or if the person doesn't own the property, right? So let's get into it this afternoon. Claremont, I'm going to be asking you some questions which you're going to answer for our audience. Like I said, audience, Claremont is licensed in New York, and he's also licensed in New Jersey. So any issue relating to both states, if you have that problem, just give us a call. Again, before I get into it, these shows are brought to you by Washington Law Firm. The number is right there, 718-877-3100. So if you are encountering any legal issues, remember, we have dual license here today to help you out. And this goes consistently, except for those areas which we do not practice. Okay, so let's get into it, Claremont. If somebody wants to perform work on their property, but they tell the person who owns either a general contractor's license or maybe just a handyman company where they perform handyman services, tell the audience what is the first thing they need to do to ensure that the proper person is signing the contract with them, or they're entering into a proper contract. And then we're going to move from that into explaining to them the process of ensuring payment is properly secured. So let's start with the first part of that. How do we ensure that it's the right person you're contracting with?
Well, you want to be sure that the person you're contracting with is the owner of the property on which you'll perform the work. Now, that might be a little complex process, but if you have any doubts, there are ways to check. The city, the county, or the city will have a list of properties, and do you know the property you're working on? You should be able to call and find out whether this person actually owns the property, or ask them to produce some kind of deed or document that they are the person. Because if they're not, and you contract with them, you may not be able to get paid later. The word mechanics lien, maybe we should explain that first, because
right. But before you explain the mechanic lien, there's just one thing I would like to tell the audience. So if you're not sure how to determine if somebody's the owner of the property, you can just give us a call and you can consult with us, and we will be able to pull that online. It's a very simple process, but I do understand that every lay person knows how to find a deed. So if you're in, and you don't have to pay initially to find a deed, because I know there's also some websites you go to the wrong website, it'll tell you need to pay a fee to get the deed. And the deed is really just public information. So you can just give us a call if you're confused and you can't figure that part out. Now we're going to move to the second part, in which Clement is going to explain to you what is a mechanic lien. Could you
Well,
explain that?
right. As the name suggests, mechanic is really a general word meaning people who fix things, who repair things, people who make things, the mechanics of things. And a lien is anything placed against the property that you will have a debt you owe that you would have to pay before you dispose of that property. So it could even a mortgage is a lien. Anything against your property is a lien. The mechanic's lien specifically is against your property for work that had been performed. Now, it may or may not have been performed to your liking. It doesn't matter. If you contracted with somebody, they performed the work and they're supposed to be paid, or you can object in court as to why they should not be paid. But once the work is completed, they have the right and they're not paid, they can file a lien against your property. Now, it's a mechanic's lien is different from those other liens in the sense that it is for work specific against a specific property. It's not a generalized lien. You can't do work for your neighbor and places against the other neighbors. It has to be very specific.
Yes, I'm glad you said that it has to be very specific. This brings me to a point that I would like to make. When Clement says it needs to be specific, for instance, if you perform work on 120 Harry's Lane, you can't put lien on 122 Harry's Lane. So if somebody takes you to a property and they say, hey, I need to get some repair done to this property, I'm the property owner, right? But you didn't check to make sure that the person is making the correct representation to you. You go ahead, you perform work on 120 Harry's Lane. And then later on, you found out that the person's name is not even on the deed for 120 Harry's Lane. But you found out that this person who you contracted with is actually the owner of 122 Harry's Lane. Then you can't put a lien on 122 Harry's Lane. And neither can you put the lien on 120 Harry's Lane because the person you're contracting with has no ownership rights or title to 120 Harry's Lane. So where does that leave you? So that's an issue that before you put any lien or think about putting a mechanic lien on a property, make sure that you're dealing with the right person and the person has authority, either a power of attorney or some valid document as a trustee or something to permit that person to put that lien or to contract with you to put that lien on the property. Now, let's get into another issue, Clement. If somebody wants to put a mechanic lien, how do they go about getting a mechanic lien on a property? Because most people, they hear the term lien and they're still not sure, what are we talking about? What are we dealing with? And how do I even go about the process of putting a lien on someone's property?
Now, this is taking into consideration that you've already performed your work and you're satisfied with the work that you did. You asked for payment. The person did not pay you. You want your money. What do? Then you go to, in most states, the process might vary, whether it's New Jersey or New York or any other state for that matter. It may vary, but generally speaking, you go to the county. There's a document, a form that you have to fill out. Again, if you're having problems or issues filling it out, you ask somebody, ask a professional. You submit that form completed, notarized to the county clerk. Once it's filed, you then have to notice the person whom you said owes you, and that lien is not forever. When you notice them, it only lasts for a year, and if you haven't received your money in that year, you have the right to file a complaint to get your money, or you can renew the lien. But if you just leave it like that, your lien would be off the property and that person can dispose of it without your knowledge. So the process is fairly simple. You go to the county clerk's office and you register the lien. They usually have a document for you to fill out, and they've made it simple because they know that these people are busy. A lot of our people like us, people from immigrant communities and so on, perform this kind of work, and we need to get paid. So they've made a fairly easy process of going to the county register, filing the document with all the information, how much money was spent, and so on. Now, this is not limited to the general contractor. Subcontractors can also file their independent liens if they have an agreement uh, directly with that person, with the owner. This may include plumbers, carpenters, roofers. Everybody can have a shot at getting their money. But to answer the question, you go to the county, you fill out the form, you notarize it, you submit it, and you notify the person who owes you the money.
Right. Thank you for explaining that to our audience. Like we said, this is for people who are engaged in the trade of carrying out home renovations, building properties, repairing properties in the form of plumbers, electricians, builders, whoever you are, whatever your trade is, as long as it relates to the line of construction, then this episode is for you. And we would like you to get your money in the event you've decided you're going to enter into a contract with somebody to perform work and then that person does not pay you. Now, Clement, I have a more tricky question to ask. Now, if somebody enters into an agreement with a property owner, but the person fails to register a mechanic lien, is there another method that you would like to explain that they can still go about to secure that money? Because I know a lot of people are watching, they probably have the same problem, but they don't know how to solve it. They did not know about the mechanic lien, so there's no lien on the person's property, but they still would like to get paid because a lot of these contractors, they invest their own money, they use their own equipment, they use their own material, and they put it on the person's property. And then after you purchase all the materials, spend thousands of dollars, and because of the ignorance, you don't know what to do. You didn't put a mechanic lien, but you still would like to get compensated, for the money you've expended or your time, your labor, and you want to figure out how could you go about doing this. Could you
Right.
explain then to the audience how could they still secure the money even in failure to secure a mechanic lien?
Right. Well, there is always the law of contracts. And the beauty of the lane is that the person cannot dispose of the property without paying you first. You're in the line to be paid once you have a lane on, and you could go to and do whatever else you're doing, knowing that that lane is filed, and any reputable title company or bank that's engaged in the transfer of that property will contact you and tell you, look, we are about to sell this property and your money is safe with us. Just show up at a certain date and get your check. Now, if you don't have the lane, it doesn't mean all is lost. We always have contract law, because anytime you do a service as part of an agreement, which is a performance contract or any other kind of service contract, it is a contract, and that person owes you. You can always go into court depending on the amount of money that's owed. It might be a small claim, or it might be a major claim if the renovations and the work done is over a certain amount, depending on what state and county you're in. And ask the court to enforce the contract, because you made an agreement, you provided the materials, you did the work, and you were never paid. And once you can support what it is that you're saying with evidence, and this does not have to be in writing, performance, and if you can prove performance, you should be able to prevail. Now, I'm not saying don't write it. If you're doing the work, it's always best to have paper written. But if you don't have a paper contract, all is not lost. If you can prove that you performed, that you hired people, that you put yourself, that you spent your own resources to get the job done, then you should be able to recover. So all is not lost if there is no mechanics lane.
Right. And thank you for explaining that. And there's just a few other things I would like to include in what you said so that the audience will understand that even if you have to file a breach of contract suit against the property owner, a lot of times the lawsuit works out best for you. But there's a caveat. If you're going to file a lawsuit, you definitely will need to put a list pendant while the lawsuit is being proceeded. Because if you don't put a list pendant, during the time that you sue the person could easily dispose of the property, like Claremont said earlier, and you will not even know. So by the time you get a judgment, you have an empty judgment because there's no property to enforce the judgment against. The person already disposed of the property. But if you're able to sue the person, put a less pendant on the property, because as long as you've done work on that property, you have an interest in the property now, because that's the only time you can put a list pendant on a property. If you have an interest in that property and your labor, your time, your material, it certainly creates an interest in the property. So if you're able to do that and you take the person to court, you sue them. If you invested $150,000, the suit is valued at that plus interest, and then you get a judgment. Just so you know, the judgment is good for an entire 20 years. So it doesn't matter now whether or not you forgot to put the lien, the mechanic lien, which, as Clement explained, is only good for 1 year. But the judgment is good for 20 years. So if the person should try to sell the property at any point after you obtain that judgment, it will record against the person on a title search. Because every time somebody tries to sell a property or to purchase one, a title search is run against that person, and they check the name for judgments. And if it comes up that they're a judgment debtor, then they will not be able to sell the property without compensating you or without paying off that judgment. So you wouldn't have to worry. And then the other caveat is to, even though there might be a judgment recorded against you, just bear in mind that as it relates to property sale, that person could only enforce the judgment against your property only for a limited time. So even though the judgment is good for entire 20 years, there's still some restrictions there. So all in all, I think a conclusion has to be drawn as to which is your best option. Now, Claremont, you knowing both angles, contract law and the lien, which one would you recommend as the best option to the audience?
Well, usually you'll file a lane uh, in a short term on a short term basis, and that if you found out that after you perform this work that this property is about to be sold, it's probably quicker to just go and get the mechanics lien uh, listed against the property, and so they'll have to come to you in order to make the sale of the transfer of the property. So it's more like an emergency basis. Now, if you have to file a breach of contract, that may take a little longer unless you can prove that there's some emergent conditions like a sale, and you would have to have access to that contract, which is not always likely. You'll have to have proof that this property is about to be sold in order to go into court on an emergent basis and say, look, these people are going to get ready to sell this property. I did some work on this property and I need my money before they sell the property. So if it's an emergency, it's probably quicker and cheaper to just do a mechanics lane, get the notices done, and be done with it. If you are a long-standing contractor with an established business, and you maybe you have a little more resources and time, you can go on the breach of contract and maybe even secure a larger judgment, including all your costs and all attorney's fees and all of that against the individual, even without sometimes with a list pendants, because you can go after other property. In their paycheck, for example, if somebody owes you money, you can get a judgment. You can go after all their assets. So that's give you a little more options to enforce your judgment. The mechanics lane, again, is sort of like a short term and a quick resolution. And sometimes it's not always quick if the person is not selling that property. They could hold that property for another 20 years and you wouldn't be able to, you may still have to go and do a breach of contract to get your money. So it's not necessarily better or worse. I think they're both very strong tools. You just have to figure out with with the advice of counsel which is the best in any specific set of facts.
Right. Thank you for explaining that. And guys, as we're getting to wind down this show, we're going to discuss some of the common mistakes that you should avoid again before wrapping up. But I just want to remind you that these shows are brought to you by my law firm, Washington Law Firm, located at 455 Utica Avenue, Brooklyn, New York. The phone number you see is right across the screen. If you need to speak with me or you want to consult with Claremont, you can call that number 718-877-3100. And we do provide a free 15 minutes legal consultation, no cost to you. But anything after that, if you would like to schedule in person or anything else, that of course will cost you. So if you need that assistance, give us a call. Now we're going to discuss some of the common mistakes that you should avoid if you're going to be placing a lien on somebody's property. One of the situations that we have recently seen is a case where a lien was placed on a property that was an estate property. Now, Claremont, could you explain to the audience how do you avoid a situation where a lien is placed on an estate property, and what should a person do if they find out a property is under an estate?
Well, in every case, you need to find out who the owner is or who's the person authorized to act on behalf of the owner. In an estate matter, the person is dead. You can't serve that person. You have to serve the person who is their representative. And in most instances, whether it's in the US, in Guyana, or Trinidad, that person has to be appointed either by court or by a trust. And so if there's a will or no will, the court still has to appoint that person. So you then, as the person who performed under the contract, has to then determine who is the person. Is this an executor? There was a will and an executor was appointed, or there's no will and an administrator was appointed. And if no one has been appointed, the question is, what do you do then? Um, so, in the instance of a trust, the trust will tell you who is the person, who's the trustee. So you have to serve that person. And when you name your lane, you will not name it in the name of the person, of the deceased person, but through under the power of the trustee, if it's a trust, or the executor administrator, if there's a will or no will. I, Shellon, you might want to go over some of that stuff because it gets muddled sometimes. But the main point is that you have to know who is responsible for the property. You can't serve the person's family member if that family member has not been appointed. It doesn't work. It can't. You might know a daughter, a son, a brother, a sister. You serve them because you know them. You're going to be out of luck because you served the wrong person. And then you will have to go on a breach of contract and sue the right person because the Mechanics Lien would have been foreclosed to you unless you renew it. You reapply. So the point of it is that find out who the right person is before you file and waste time.
Right. That's perfect. Thank you for explaining that. And just one other thing, guys. I do understand that there's times when you can't determine if own property owner is alive or dead because there's no way to tell. It's not necessarily that you're going to find an obituary online to tell you, oh, this property owner is no longer alive. Don't do any work on this property. So in those instances where there's uncertainty, you can't tell, the best thing to do is pick up the phone and call an attorney to do the work for you, because there are not always times when you're going to be able to determine the true identity of a person or the true owner of a property. Anybody could make a misrepresentation to you. It's up to you as a contractor to ensure that you ask for an identification of the person. Then you go dig for the deed. And if you don't have the time to do that, the best thing is to pay an attorney to do the work for you. That way, you'll ensure that everything is done correctly. And as Claremont says, there's different persons or capacity under which a person might be holding a deed. It might be a trustee, it might be an executor, an administrator. You don't know. And if you can't ascertain for yourself, the best thing, pick the phone up and give us a call, or call your attorney if you already have one. If you would like us to help you, and if we have said anything here today that you think might be of use to you and help you in your line of business, again, like I said, you can pick up the phone and give us a call. Available Monday to Friday, 9 a.m. to 5:30 p.m. And the number is right across the screen, 718-877-3100. Give us a call if you're in need of legal consultation. Okay, guys? And if you got any question regarding today's content also, if it affects you in any way, just give us a call. Now, just one last housekeeping issue as it relates to the different capacity that a person can hold a property in. For instance, I hold property for clients as trustee. So if there's an issue, anybody would need to consult or contact me to deal with that issue. But it doesn't necessarily mean that any actions that I take, it doesn't necessarily mean my beneficiary or my grantor may agree with it. So if that's the case, you will need to get into the trust instrument itself. Under the trust that I would serve under, I would have authorization to do anything for my grantor and for my beneficiaries. But not all trusts are so widely or so versatile that it allows the trustee with unfettered authority. That the authority might be restricted. There might be certain things under the trust that you may need to be familiar with before you even decide that you're going to do repairs on any property that a person represent to be a trustee on. So just be careful, guys. And like I said, as always, it's better to seek legal advice before you do something that you're not familiar with. Now, thank you so much, Claremont. Do you have any closing remarks today for the audience before we
No,
go?
just to be very careful their dealings, to call if they have any questions about this or any other questions that they might have that they would like to see us address on this program.
Thank you so much, Claremont, for joining me today. And as always, I appreciate your presence. My audience appreciates your presence. And thank you guys so much for joining us. And I do hope you enjoy the rest of your weekend. Today is Saturday. Happy Saturday, and enjoy your Sunday. And I guess it's back to work on Monday for most of us. So thank you for joining us. And we will see you again next Saturday at 4 p.m. I know in my last video I made a mistake and say 4:30, but it's never 4:30, guys. It's always 4 o'clock. Okay. See you next Saturday at 4 p.m. And as usual, today's edition was brought to you by Washington Law Firm. Thank you, guys. See you again next Saturday.
Thank you.